Before we begin, a quick and important disclaimer. This video is intended for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. The laws, social norms, and judicial practices discussed are historical in nature and vary significantly by jurisdiction and time period. Divorce laws are complex and have changed radically since the 1950s. Viewers should conduct their own due diligence and consult with a licensed legal professional for any contemporary legal matters. In 1955, a middle-aged man walks into a wood-paneled office in downtown Manhattan. He isn't there to discuss his portfolio or his career at the firm. He is there because his life, as the American dream defines it, has become an unbearable cage. But as he sits across from his attorney, he realizes something terrifying. In the eyes of the law, he cannot simply choose to leave. In the United States of the 1950s, divorce wasn't a civil liberty. It was a legal battleground where you had to prove a crime had been committed. If you couldn't prove your wife was a dynamic villain, or if she refused to play along with a scripted lie, you were stayed married for life. Welcome to the era of the fault-based divorce system, a time when ending a marriage was arguably more difficult, more expensive, and more socially ruinous than at any other point in American history. We are diving into the hidden world of the 1950s male experience, where men were caught between the crushing pressure of the breadwinner trap and a legal system designed to punish the person who dared to break the nuclear family unit. By the end of this deep dive masterclass, you will understand exactly why the 1950s weren't just the decade of white picket fences, but the decade of the divorce underground. We are going to deconstruct the actual mechanics of how men navigated the Reno cure, the secret industry of staged adultery photos, and the brutal financial math of permanent alimony. If you've ever wondered why your grandfather's generation stayed in miserable marriages for 40 years, or why the 1960s exploded into a social revolution, the answers are buried in the cold, hard legal realities of 1955. This is the blueprint of the mid-century male psyche under pressure. To understand the 1950s man, you must first understand the concept of fault. Today we have no-fault divorce, where irreconcilable differences is the standard. In the 1950s, that didn't exist. To get a divorce, one party had to be the innocent spouse, and the other had to be the guilty party. You could not simply agree that you had fallen out of love. If both parties wanted the divorce and admitted it, the judge could actually throw the case out under a legal doctrine called collusion. The law viewed marriage as a permanent contract with the state, and the state didn't want to let you out of it unless someone had been wronged in a way that violated the sanctity of the union. The recognized faults were narrow and harsh. Adultery was the gold standard, followed by desertion, physical cruelty, and in some states, incurable insanity or a felony conviction. For a man in the 1950s, this created a massive strategic dilemma. If he was the one who wanted to leave because he was unhappy or had met someone else, he was the guilty party. In the social and legal landscape of the time, being the guilty party meant more than just a bruised reputation. It meant the court would likely strip him of his assets, grant him zero custody of his children, and saddle him with alimony payments that could consume 50% or more of his pre-tax income for the rest of his life. Take the case study of a typical suburban professional in 1952. Let's call him Robert. Robert is a mid-level manager. He has a wife, 2 children, and a mortgage in a developing suburb. He is miserable. There is no abuse, no crime. Just a cold, dead marriage. Under the laws of New York State in 1952, the only grounds for divorce was adultery. Robert couldn't just walk away. If he tried to sue for divorce without evidence of his wife's infidelity, he would lose. If he admitted he was the one who wanted out, his wife's lawyer would use that as leverage to demand every cent he had. This led to the rise of the professional correspondent. Because the law required proof of adultery, and many couples actually did want to split up amicably, a shadow industry emerged. A man would hire a woman, often provided by a private investigator, to meet him at a hotel. They would sit on the bed, fully clothed, perhaps sharing a drink. A photographer would burst in, snap a photo of them in a compromising position, and that photo would be presented in court as the proof of fault. The wife would then sue the husband for divorce on the grounds of his adultery. The husband would confess, the judge would grant the decree, and the husband would pay a massive premium in alimony as the price for his freedom. This was a staged play, a legal fiction that everyone, the lawyers, the judges, and the spouses, knew was a lie, but it was the only way the system allowed the exit door to open. But what happened if the wife didn't want the divorce? This is where the power dynamics of the 1950s get incredibly dark for men. Since the man was usually the sole breadwinner, the wife had a massive incentive to contest the divorce. If she refused to grant him a divorce, and he couldn't prove she had committed a fault, he was legally tethered to her indefinitely. Men would spend years living in bachelor apartments, while still paying the full mortgage and expenses of their family home. Unable to remarry, unable to move on, living in a legal limbo. This created a culture of legal blackmail. A wife could demand the house, the car, and a huge portion of future earnings in exchange for allowing the divorce to proceed by not contesting the husband's fabricated or real fault. We also have to look at the Reno cure. For men who had the financial means, the strict laws of states like New York were a brick wall. This gave birth to Reno, Nevada, as the divorce capital of the world. Nevada had a 6-week residency requirement. A man would take a leave of absence from his job, fly to Reno, stay in a divorce ranch for 6 weeks to establish residency, and then take advantage of Nevada's much more liberal divorce laws, which included extreme cruelty, a catch-all term for mental unhappiness. This was a luxury of the elite. For the average working-class man, Reno was a fantasy. He was stuck in his home state, stuck in a fault-based system, and stuck with the social stigma. In the 1950s, a divorced man was often viewed with suspicion in the corporate world. Large corporations of the era, the organization man culture valued stability. A divorce was seen as a sign of poor character or an inability to manage one's own affairs. It could stall a promotion or result in being quietly let go. The pressure wasn't just coming from the wife or the court, it was coming from the boss and the neighbors. As we move deeper into this masterclass, we're going to look at the financial destruction of these settlements. In an era before women were widely encouraged to have careers, alimony wasn't just a temporary bridge, it was often permanent. A man could be paying for his fault for 30 years, effectively working 2 jobs, one to support his new life and one to support the ghost of his old one. We are going to look at the specific mathematical breakdown of a 1950s divorce settlement and how it led to a generation of men who felt like they were nothing more than an ATM in a gray flannel suit. To understand the true weight of the financial burden placed on men in the mid-1950s, we have to look at the math of the era through the lens of a case study. Imagine a man named David living in a suburb of Chicago in 1956. David is 34 years old and works as a senior account executive. He earns an annual salary of $7,500. In 1956, this is a solid, middle-class income that allows for a 3-bedroom ranch house, a late-model Ford in the driveway, and a stay-at-home wife named Margaret and their 2 children. But the marriage has fractured. David wants out. Because Illinois at the time operates under strict fault-based statutes, David finds himself in a financial vice before he even steps foot into a courtroom. The first mathematical hit is the preliminary alimony and counsel fees. In the 1950s, the legal system operated on the assumption that since the husband controlled the purse strings, the wife had no means to defend herself. Therefore, a judge would frequently order the husband to pay his wife's legal fees up front. David isn't just paying his own lawyer. He is effectively funding the legal weapon being used against him. This could immediately drain his modest savings of $1,200, leaving him with zero liquidity as the process begins. Then comes the permanent alimony calculation. Historical trends show that in contested fault-based divorces where the husband was found at fault, even if that fault was a staged adultery scene, the court's primary objective was to ensure the wife and children remained in the status to which they were accustomed. For David, this meant the court could award Margaret the family home outright, or at least the right to live in it until the children reached the age of 21, while David continued to pay the mortgage, the property taxes, and the insurance. This was known as the roof over their heads provision. Now, let's break down David's $7,500 salary. After federal income taxes and Social Security, his take-home pay might be around $6,000. A typical court order in 1956 could mandate that David pay 35% of his gross income in alimony and another 15% in child support. That is 50% of his gross pay, or $3,750, gone before he even buys a loaf of bread for himself. He is left with $2,250 for the year. From that remaining amount, he has to find a bachelor apartment, pay for his own commute, buy his own food, and attempt to maintain the professional appearance required by his firm. In this scenario, David has effectively experienced a 70% drop in his standard of living, while Margaret and the children maintain 100% of theirs. This created what sociologists of the time called the alimony slave. David is legally bound to a high-productivity career just to remain solvent. If he tries to take a lower-paying job that is less stressful, Margaret's lawyers can return to court and argue that he is willfully underemployed to avoid his obligations. The 1950s man wasn't just losing a wife, he was losing the right to control his own labor. Step by step, the financial erosion continued through the division of personal property. In the 1950s, the concept of equitable distribution was in its infancy. Most assets were tied to the house. The furniture, the appliances, and even the family silver were often awarded to the innocent party, the wife. A man like David would often leave the family home with nothing more than his clothes, his personal papers, and perhaps his golf clubs. He was starting over from zero at age 35, but with a permanent debt ceiling attached to his future earnings. Furthermore, we have to discuss the lack of tax relief. Before the major tax reforms of later decades, alimony payments weren't always as cleanly deductible for the payer as they became later. This meant David was often paying taxes on money he never even saw. He was being taxed on $7,500 while living on $2,250. This math didn't just hurt, it was a mathematical impossibility for many men, leading to a massive rise in what was then called skip tracing. Men who simply could not meet these obligations would disappear, moving to another state and changing their names to escape the financial shadow of a fault-based decree. Imagine the psychological impact. In 1956, David is sitting in a cramped, one-room apartment in a less desirable part of town. He is eating canned soup while his former neighbors see his wife and children still living in the suburban ranch house he is still paying for. Every time he gets a raise at work, he knows a portion of it will likely be claimed by his ex-wife's attorney through a petition for an upward modification of alimony. The incentive to innovate, to take risks, or to excel in his career is replaced by a grinding necessity to satisfy a court order. This financial structure was designed to be a deterrent. The state used the threat of poverty to keep men in marriages. If the price of freedom was the permanent loss of 50% of your future earnings and the total loss of your current assets, most men chose to stay and endure a silent, cold war in the living room. This is why the 1950s produced the trope of the henpecked husband or the man who stayed late at the office every night. The office was the only place he felt like he had any agency, yet the office was also the engine that fueled his financial incarceration. But the financial side was only half the battle. There was an even more devastating lever used against men in the 1950s, the absolute loss of fatherhood. While today we strive for 50-50 shared parenting, the 1950s operated under a legal doctrine so powerful it was almost never questioned. It was called the tender years doctrine. This doctrine held that during a child's tender years, which judges often interpreted as any age up to 16, the mother was the only person capable of providing proper care. For a man like David, this meant that his role as a father was legally reduced to that of a visitor and a provider. He went from being the head of the household to being a guest in his children's lives for 4 hours every other Sunday. The emotional toll of this transition was profound, yet it was rarely discussed in the masculine culture of the time. A man was expected to take it on the chin and keep working. But as we explore the 1950s deeper, we find that this total exclusion from the home led to a specific kind of male mid-century crisis that would eventually change the face of American psychology. The man of 1956 was trapped in a system that demanded he be a provider while stripping him of the family he was providing for. He was an economic ghost. If he remarried, the financial pressure doubled, as he now had to support a second household while his first alimony obligation remained unchanged. This created a cycle of debt and resentment that was a ticking time bomb for the social fabric of the country. But what happened when the man wasn't the one who wanted the divorce? What happened when the wife decided to leave and used the fault-based system to her advantage by accusing the husband of extreme cruelty? In an era where a man's reputation was his currency, an accusation of cruelty in a public court record could be a death sentence for a career. We are about to look at the weaponization of the legal system and the terrifying reality of the vindictive decree. If you think the financial math was bad, wait until you see how the 1950s legal system handled the destruction of a man's character to secure a higher payout. The next chapter of this deep dive reveals the dark side of courtroom testimony where the truth was often the first casualty. To understand the weaponization of the 1950s legal system, we must examine the tactical use of the cruelty allegation. In an era where divorce was only granted upon proof of a marital crime, the definition of extreme cruelty became a legal Swiss Army knife. For a man in 1957, Being served with divorce papers wasn't just a domestic notification. It was often the start of a public character assassination. Since historical trends necessitated a clear villain, the plaintiff, usually the wife, had to present a narrative of suffering that would satisfy a conservative judge. Imagine a man named Arthur. Arthur is a quiet, unassuming architect in Connecticut. He has never raised his hand to his wife, he doesn't drink to excess, and he provides a comfortable life. However, his wife Eleanor wants to end the marriage to pursue a different life. Under the laws of 1957, she cannot simply cite unhappiness. To secure the divorce and the maximum financial settlement, her legal strategy must involve painting Arthur as a monster. This was the birth of the narrative of mental cruelty. The step-by-step execution of this strategy often began with the Bill of Particulars. This was a legal document where Eleanor would list every perceived slight, every argument, and every cold shoulder Arthur had ever given her, but amplified through the lens of legal trauma. In court, simple disagreements were reframed as systematic emotional abuse. If Arthur worked late, it was documented as willful neglect. If he was quiet at dinner, it was characterized as the silent treatment intended to cause nervous exhaustion. This created a devastating catch-22 for Arthur. If he contested these lies in court, he was essentially fighting to stay married to a woman who was publicly testifying that she hated him. If he didn't contest them, he was legally admitting to being a cruel husband. An admission of cruelty carried heavy judicial weight. In 1950s jurisprudence, a man found guilty of cruelty was viewed as having forfeited his right to equitable treatment. The potential outcomes for Arthur were grim. The judge, acting as a moral arbiter, would often punish the cruel husband by awarding the wife an even larger share of his future earnings as a form of compensatory justice. The data from this era suggests that the mere threat of these public allegations was often enough to force men into lopsided private settlements. A man in a high-status career such as a doctor, a lawyer, or a corporate executive could not afford to have the word cruelty attached to his name in a public record. The local newspapers of the 1950s frequently ran a column of recently filed divorce petitions. If Arthur's clients or his partners at the architecture firm read that he was being sued for extreme cruelty, his professional credibility would evaporate. The legal system effectively empowered a form of institutionalized extortion, where a man would trade his entire life savings just to keep the testimony behind closed doors. Now, consider the role of the private investigator in this character destruction. In the 1950s, PI agencies made a fortune on domestic surveillance. If a wife suspected her husband was even thinking about leaving, she could hire an investigator to follow him. Every lunch with a female colleague, every stop at a bar on the way home, and every late night at the office was photographed and logged. These logs were then used as leverage. The goal wasn't just to prove a fault, but to create a dossier of humiliation. Case studies from the mid-50s reveal the use of the raiding party. This was a coordinated legal maneuver where a wife, her lawyer, a private investigator, and often a hired photographer would break into a husband's apartment or hotel room if they suspected he was with another woman. They would literally catch him in his underwear, flashbulbs popping, to create undeniable evidence of adultery. For a man in 1958, these photographs were the end of his social life. There was no digital footprint to scrub. The physical evidence was presented in open court, and the shame was permanent. This leads us to the concept of recrimination. This was a bizarre legal doctrine that made divorce even more difficult. Recrimination meant that if both the husband and the wife were found to be at fault, for example, if both had committed adultery or both were cruel, the judge would refuse to grant the divorce to either of them. The law's logic was that since neither party was the innocent spouse, the court would not provide relief. This effectively sentenced two people who hated each other to remain legally bound together in a perpetual state of conflict. For the man, this meant he remained financially responsible for a woman he was actively warring with, while also being legally barred from moving on with a new partner. Imagine the psychological warfare of a house divided under the law of recrimination. A man and woman living under the same roof, unable to divorce, each trying to goad the other into a fresh fault that could be documented by a hidden microphone or a hired witness. This wasn't just a bad marriage, it was a state-mandated cage match. Men would often move into the basement or a spare room, living as a stranger in a house they were still paying for, while their every move was monitored for a potential legal slip-up. We must also address the impact of the perjury culture. Because the legal bars for divorce were so high, many couples entered into a secret pact to lie to the court. This was called collusion. The husband would agree to let the wife accuse him of a fault he didn't commit, usually a minor form of cruelty, so the judge would grant the decree. However, the man was taking a massive risk. If the judge sensed the parties were in agreement, he could dismiss the case and refer the couple for a criminal investigation for perjury. The 1950s man was forced to be a convincing actor in a play where the script was written by a lawyer, and the stakes were his entire future. The social cost was equally high. In 1959, a man who was divorced was often excluded from the very social circles he needed for his career. The country club, the neighborhood dinner parties, and the local civic organizations were built on the foundation of the nuclear family. A divorced man was a loose thread in the social fabric. He was the odd man out at the dinner table, often viewed as a predator by other wives or a failure by other husbands. This isolation led to a hidden epidemic of male depression and alcoholism, which were often masked by the era's demand for stoic resilience. The legal system didn't just take a man's money. It took his identity as a respectable member of the community. It forced him into a choice between financial ruin and moral compromise. If he wanted to remain a good man in the eyes of his children and his church, he often had to accept a life of quiet desperation. If he wanted his freedom, he had to accept being labeled a villain. But as we peel back the next layer of this masterclass, we have to look at the most protected asset of the 1950s, the pension. For many men, their entire life's work was tied to a company pension plan. In the 1950s, the battle for the pension was the ultimate high-stakes endgame. We are about to dive into how the courts began to view a man's future retirement as a marital asset to be carved up, and the desperate measures men took to protect their only hope for an independent old age. We are also going to look at the rise of the private settlement, and the darkroom negotiations where men traded their houses for their sanity. What happens when the man has nothing left to give but his future? The answer lies in the brutal negotiation tactics of the late 1950s divorce bar. The late 1950s marked a pivot point in the American legal landscape where the battlefield shifted from the courtroom to the smoke-filled offices of matrimonial attorneys. By 1959, the stakes had reached a fever pitch because the definition of a man's assets was expanding. It was no longer just about the car in the driveway or the cash in the savings account. The new frontier was the pension. To understand the gravity of this, imagine a man named Thomas. Thomas is 50 years old, a devoted employee at a steel manufacturing plant in Pennsylvania. He has worked there for 25 years. His primary motivation for enduring decades of grueling shifts was the company pension, a solid promise of security that would allow him to retire at 65 with a dignified income. However, as Thomas enters the divorce process, he discovers a terrifying legal reality of the time. While the law varied by state, the historical trends of the late 50s began to see courts treating future pension rights as a form of deferred compensation that belonged, at least in part, to the marital estate. For Thomas, this felt like a heist. He was being told that the 25 years of physical labor he had invested were not his alone. His wife's attorney argues that because she maintained the home while he worked, she is entitled to a significant percentage of his future retirement checks. This created a specific form of negotiation known as the pension trade-off. Step by step, the process looked like this. Thomas's lawyer would meet with his wife's lawyer in a windowless room. The wife's side would threaten to go to trial and argue for a lifetime of high alimony and a share of the pension. To avoid this, Thomas would be forced to make a catastrophic concession in the present to save his future. He would often agree to give up the entirety of his equity in the family home, and all liquid cash assets immediately in exchange for his wife signing away her rights to his future pension. Thomas would walk away with his retirement intact, but he would literally be homeless the day the decree was signed, possessing nothing but his clothes and the right to keep working for another 15 years. This scenario was a common potential outcome for the mid-century blue-collar worker. It was a choice between immediate poverty and future destitution. The data from this period suggests that men overwhelmingly chose to sacrifice the present. They would sign over the deed to the suburban house, the very symbol of the American dream they had spent the 1950s building, just to ensure that when they were too old to work, they wouldn't be begging for change. This resulted in a generation of men who, in their 50s and 60s, were forced to move back into boarding houses or small rentals, starting their lives over with a mattress on the floor while their ex-wives remained in the fully paid-off family home. Beyond the physical assets, we must address the hidden cost of the private settlement agreement. In the 1950s, because the public court records were so damaging, men were often willing to sign side agreements that were even more punitive than what a judge might order. These were essentially hush money contracts. If a man like Thomas had a secret, perhaps a struggle with a vice or a private relationship that hadn't yet been discovered, the wife's attorney could use the threat of a public discovery phase to extort astronomical sums. This wasn't called extortion in the legal briefs. It was called a voluntary property settlement. The psychological weight of these negotiations cannot be overstated. A man was essentially bidding on his own freedom. Imagine if you were told that to stop living in a house full of resentment and silence, you had to pay a $100,000 exit fee in an era where that was 4 times the value of a house. For the 1950s man, this led to a phenomenon called the second job syndrome. To afford the settlement payments and still have enough to eat, men would take on night shifts, weekend consulting, or manual labor on the side. They were working themselves into early graves to pay for a life they were no longer allowed to live. This brings us to the actual mechanics of the final decree. In 1959, the day the judge signed the papers was not a day of celebration for most men. It was a day of total liquidation. The step-by-step process of moving out day was a ritual of humiliation. Under the watchful eye of the law, and often the neighbors, the man would pack his suitcase. In many jurisdictions, if the wife was the innocent party, she had the right to keep almost everything inside the 4 walls. The man didn't just lose his wife. He lost his chair, his radio, his books, and his connection to his own history. Consider the case study of a man named Frank, a salesman in Ohio. When his divorce was finalized in 1958, the court order was so specific it dictated which kitchen utensils he could take. He was allowed 1 frying pan, 2 plates, and his personal shaving kit. Everything else, the dining table where he had celebrated every holiday, the record player he had saved for 3 months to buy stayed. This wasn't just about the objects. It was about the systematic stripping of a man's identity. When Frank moved into his new, empty apartment, the silence was a physical weight. The legal system had achieved its goal. It had punished the man who broke the union by reducing him to a state of near infancy, starting over with nothing. We also have to look at the life insurance trap. A common requirement in 1950s divorce decrees was for the husband to maintain a massive life insurance policy with the ex-wife as the sole, irrevocable beneficiary. The man was required to pay the premiums for the rest of his life. This created a macabre financial incentive. The man was worth more to his ex-wife dead than alive. For 20 years after a divorce, a man would see a significant chunk of his paycheck go toward a policy that would only benefit the woman who had sued him for cruelty decades earlier. It was the ultimate ATM scenario. He was providing for her even from beyond the grave. If he failed to pay the premiums, or if he fell behind on alimony, the 1950s legal system had a very fast solution: jail. This wasn't a civil matter that took years to resolve. Contempt of court was a powerful tool. A man who missed 2 months of payments could find himself behind bars in a local county lockup. This was the ultimate irony. The state would take a man away from the job he needed to pay the alimony, because he hadn't paid the alimony. The social shame of alimony jail was a powerful deterrent that kept men working in jobs they hated, living in conditions they loathed, just to stay 1 step ahead of the sheriff. As we conclude this section of the masterclass, we see a picture of a man who has been legally, financially, and socially dismantled. But there is one final piece of the 1950s divorce puzzle that is perhaps the most tragic of all. It is the story of the forgotten father. While the financial math was brutal, the emotional math was a total loss. We are about to dive into the era of the Sunday dad, and the psychological impact of being a guest in your own children's lives. We will explore how the legal system of the late 50s systematically erased the father-child bond, and the long-term effects this had on the children of the silent generation. What happens to a man's mind when he is told his only value is his paycheck? The answer is found in the dark statistics of the 1960s, which we are about to uncover. To truly grasp the emotional erasure of the 1950s father, we must dissect the lived reality of the visitation schedule. In the year 2026, we view shared parenting as a standard goal, but in 1959, the legal system functioned on the absolute binary of the custodial parent and the visitor. Once the judge signed the decree, a man's relationship with his children was governed by a rigid, often cold set of rules that prioritized maternal stability over paternal bonding. Step by step, the transition from head of household to Sunday dad was a process of systematic alienation. Imagine a man named Richard. Richard is a devoted father in a suburb of Atlanta. Before the divorce, he spent his evenings playing catch in the backyard and reading bedtime stories. But under the typical 1950s decree, Richard is granted visitation only on the first and third Sunday of every month, from 1 p.m. to 6 p.m. Imagine the psychological shift of that first Sunday. Richard pulls up to the curb of the house he still pays the mortgage for. He is not allowed to use his key. He must ring the doorbell of his own former home and wait on the porch like a delivery driver. His children are ushered out to him, often dressed in their Sunday best, creating a formal barrier that prevents any natural interaction. This created the phenomenon of the performance parent. Because Richard only has 5 hours with his children every 2 weeks, he feels a desperate pressure to make every second count. He cannot simply be a father. He has to be an entertainer. Historical trends from this era show that men would take their children to zoos, department store toy aisles, or movie theaters, places where they didn't have to talk about the trauma of the split. They were essentially buying their children's affection because the legal system had robbed them of the ability to participate in the mundane, essential acts of parenting like helping with homework or sitting through a feverish night. The data regarding child development from the late 1950s began to show the cracks in this model. While the tender years doctrine assumed children only needed their mothers, the reality for the children of the silent generation was a profound sense of loss. For the father, the potential outcomes of this restricted access were often a slow, painful withdrawal. After months or years of being treated as a guest, many men found the emotional pain of the short, supervised visits too much to bear. It was a form of psychological torture to see your children growing up through a series of 5-hour snapshots. Consequently, some men began to skip visits, not out of a lack of love, but as a defense mechanism against the agony of the constant goodbye. The legal system then used this withdrawal as further proof of the father's lack of interest, creating a self-fulfilling prophecy of abandonment. Consider the case study of a man named Michael in 1958. Michael was a veteran and a disciplined worker. When his visitation was restricted, he tried to stay involved by attending his son's Little League games. However, his ex-wife's attorney argued in court that his presence at the games was a violation of the spirit of the decree and caused emotional distress to the mother. The judge issued a restraining order, barring Michael from any contact outside the designated Sunday window. This was the weaponization of the best interests of the child standard, which in the 1950s was almost exclusively interpreted as whatever makes the mother's life easier. Michael was effectively erased from his son's athletic and social life, relegated to a spectator in a different zip code. The emotional math for these men was a total deficit. They were told by society that their masculinity was defined by their ability to provide and protect. Yet, the law took away their ability to protect their children's daily well-being, while doubling down on their requirement to provide. This led to a specific type of mid-century male depression that was often misdiagnosed or ignored. Men were expected to have stiff upper lips. They were told to focus on their work. But when a man spends 40 hours a week in a high-pressure office and then returns to a silent, empty apartment, the lack of purpose becomes a corrosive force. We must also examine the holiday clause. In the 1950s, the mother almost always received the children for every major holiday: Christmas, Thanksgiving, and Easter. The father might be granted a few hours on the Saturday before, but the core traditions of the family unit were stripped away from him. Imagine the scene in a 1950s boarding house on Christmas Day. Dozens of divorced men, sitting alone in wood-paneled rooms, while the families they funded were celebrating in the suburbs. This isolation contributed to the era's rising rates of male cardiovascular issues and stress-related illnesses, which medical case studies from the early 1960s began to link to the social dislocation of divorced males. Furthermore, let's look at the stepfather shadow. In the late 1950s, the social pressure for a divorced woman to remarry was immense. When the mother remarried, the biological father's position became even more precarious. The new husband would often move into the family home, the home the biological father was likely still paying for via alimony or property settlements. The biological father was then in the position of funding the lifestyle of the man who was effectively replacing him in his children's lives. In some states, the mother could even petition to change the children's last names to that of the stepfather, a move that was often granted if the biological father had fallen behind on a single payment or missed a few visits due to work. This was the ultimate erasure, the removal of the man's name from his own lineage. Step by step, the 1950s legal system was designed to clean up the mess of a broken marriage by pushing the father out of the frame as quickly and quietly as possible. The goal was to re-establish a nuclear family unit, even if it was a synthetic one with a new stepfather. The biological father was seen as a logistical hurdle to be cleared. He was the payer, not the parent. This environment created a generation of ghost dads. These were men who were physically present in the economy but emotionally absent from the next generation. The impact of this on the children of the 50s cannot be overstated. They grew up seeing their fathers as distant, burdened figures who appeared occasionally with gifts but had no real say in their lives. This created a cycle of resentment that would eventually boil over in the counterculture movements of the late 1960s. As the children of these fractured 1950s homes began to question every institution their parents held dear, especially the institution of the traditional marriage and the laws that governed it. But there is a hidden layer to this story that involves the men who fought back. Not through the courts, which were rigged against them, but through a secret network of underground support. In the twilight of the 1950s, men began to organize in ways that the public never saw. We are about to explore the gray market of 1950s divorce, the secret societies of men who helped each other disappear, the paper trip experts who created new identities, and the rise of the first fringe fathers' rights groups that were considered radical for simply asking for an extra afternoon with their sons. What happened when the most compliant generation of men in American history finally reached their breaking point? The answer involves a massive silent exodus that the IRS and the FBI were completely unprepared for. The next part of our masterclass reveals the high-stakes world of the vanishing men and the desperate lengths they went to for a second chance at life. As the 1950s drew to a close, a silent crisis reached its boiling point. The legal and financial pressure on the American man had become so absolute that a segment of the population chose a radical, desperate path. This was the era of the vanishing men. To understand this, imagine a man named Stephen. Stephen is a 38-year-old insurance salesman in Indianapolis in 1959. He is current on his alimony. He has attended every supervised visitation, and he has surrendered his house. But the math no longer adds up. Between his tax obligations, his rooming house rent, and the increasing demands for upward modification of child support from his ex-wife's attorney, Stephen is effectively working 60 hours a week to live on the equivalent of a janitor's wage. One Tuesday afternoon, Stephen parks his car at the train station, leaves the keys in the ignition, and simply disappears. This was not an isolated incident. Historical trends show that the late 1950s saw a massive spike in what were then called runaway dads. Because there was no centralized digital database in 1959, no national credit score system, and no interconnected state computer networks, a man with enough resolve could erase his identity and start over. Step by step, the process of vanishing was a cold, calculated maneuver. A man would slowly liquidate small personal items for cash over several months. He would apply for a duplicate social security card under a slightly different name or use the birth certificate of a deceased infant, a technique known as the paper trip. By the time the sheriff arrived to serve a summons for unpaid alimony, the man was 3 states away, living under a new name with a new job and a completely clean slate. The data from the early 1960s, looking back at this period, suggests that thousands of men utilized this desperate exit. The FBI and the IRS were largely powerless because these men weren't traditional criminals. They were middle-class professionals who had reached a breaking point. They moved to booming frontier economies like California, Florida, or Arizona, where labor was in high demand and questions were rarely asked. For Stephen, the potential outcomes were a life of constant looking over his shoulder, but to him, that was preferable to the slow-motion financial execution he was facing in Indiana. He was trading his history for his future. This phenomenon led to the rise of a shadow industry, the skip tracers. Private investigators in the late 1950s began to specialize in finding these vanishing men. They would haunt the local post offices, check the records of professional licensing boards in other states, and interview former coworkers. The battle between the runaway husband and the skip tracer was a high-stakes game of cat and mouse. If caught, the man faced immediate incarceration in a debtor's prison and a complete loss of any remaining legal standing. Yet, the volume of men willing to take this risk highlights just how punitive the 1950s divorce system had become. While some men vanished, others stayed and began to organize the first whispers of what we now recognize as a social movement. In 1958 and 1959, small informal gatherings began to take place in the backrooms of diners and community centers. These were the first fathers' rights groups, though they didn't yet have that name. They called themselves things like the Divorce Reform League or the League for Equitable Alimony. These men were pioneers of a radical idea, that the law should be based on current reality, not on Victorian-era moral judgments. They began to pool their resources to hire lobbyists and challenge the constitutionality of permanent alimony. Case studies of these early groups show a fascinating tactical shift. They realized that they couldn't win on emotion because the public viewed them as failures. Instead, they attacked the system through the lens of economic efficiency. They argued that the fault-based system was a drag on the American economy. They pointed out that thousands of productive men were being driven into the underground economy, or early retirement, because the tax and alimony burden removed all incentive to earn. They were essentially using the language of the Cold War, arguing that America needed its men at peak productivity to beat the Soviets, to argue for divorce reform. Imagine the courage it took for a man in 1959 to stand up in a public hearing and admit he was divorced. It was a social death wish. These men were the first to suggest that maybe, just maybe, a marriage could fail without one person being a criminal. They proposed the revolutionary concept of no-fault divorce, an idea that was met with absolute horror by the religious and legal establishments of the day. The American Bar Association at the time viewed no-fault divorce as the end of Western civilization. Judges argued that without the threat of financial ruin and social shame, the nuclear family would evaporate overnight. To see how high the walls were, look at the legal doctrine of the clean hands. In many 1950s courts, if a man wanted to ask for a reduction in alimony because he had lost his job or suffered a heart attack, he had to prove he had clean hands. If he was behind by even $1, or if he had been late to a single visitation, the judge would refuse to even hear his motion. He was trapped in a cycle of perfection. If he wasn't a perfect provider, he had no rights. If he had no rights, he couldn't survive. This rigidity is what fueled the anger that would eventually explode in the 1960s. Let's look at the example of a man named George in 1959. George was a schoolteacher who suffered a debilitating back injury. He could no longer work full-time. He went to court to ask for a reduction in his $200 a month alimony payment. The judge looked at George's record and saw that George had once been seen in a bar on a Saturday night. The judge ruled that if George had money for a beer, he had money for his ex-wife, and denied the motion. George was ordered to pay the full amount or face jail, regardless of his physical inability to work. This was the face of the innocent spouse bias. The woman's right to support was seen as an absolute, while the man's right to physical and mental health was seen as a luxury. This environment created a unique bond between these men. They began to share survival tips for the divorced male. They traded information on which states had the most lenient judges, which lawyers were willing to actually fight for a father's rights instead of just facilitating a surrender, and how to hide assets in offshore accounts or private trusts. This was the beginning of the divorce underground, a network of men helping men navigate a system that viewed them as disposable engines of capital. But the most significant development of the late 1950s wasn't the vanishing or the lobbying. It was the psychological shift within the men who stayed. They began to realize that the life they had been told to build, the corporate job, the suburban home, the compliant family, was a house of cards that could be blown over by a single legal filing. This realization birthed a new kind of American cynicism. The men of the late 50s were the first to truly understand that the state was not their partner in the family unit. The state was the referee who could, at any moment, eject them from the game and keep their jersey. As we move into the final chapters of this masterclass, we are going to look at the exact moment the dam broke. We are going to look at the landmark cases that finally started to chip away at the tender years doctrine and the permanent alimony trap. But before that, we have to look at the most controversial part of the 1950s male experience, the second family. What happened when a divorced man tried to love again? We are about to dive into the step household crisis, and the impossible choices men had to make between their children from the first marriage and their children from the second. The legal system was about to be hit with a demographic wave it couldn't ignore, the rise of the remarried man, and the battle for the prioritized paycheck. Who gets fed first when there isn't enough for everyone? The answer will change everything you think you know about 1950s family values. By the dawn of 1960, the American legal system collided with a demographic reality it was never designed to handle: the man who dared to start over. In the mid-century mindset, divorce was supposed to be a finality, a social exile that effectively removed a man from the pool of respectable family life. But men were humans, not just legal entities, and they began to fall in love again. This created the crisis of the second family. To understand the sheer mathematical impossibility of this, imagine a man named Henry. Henry is a 40-year-old foreman at a manufacturing plant in Michigan. He has been divorced for 3 years from his first wife, Beatrice. Under the terms of his 1957 decree, Henry is paying 40% of his take-home pay to Beatrice in permanent alimony and child support for their 2 children. In 1960, Henry meets a woman named Sarah, a widow with a child of her own. They decide to marry. Henry now enters a world of financial and legal schizophrenia. Under the law, his primary obligation is still to his first household. The court views his second marriage as a luxury or a voluntary choice that should not diminish the standard of living of the first wife. This meant that if Henry and Sarah had a child together, that new infant was legally a second-class citizen. In many jurisdictions during the late 1950s and early 1960s, a man could not use the birth of a new child as a grounds for reducing his support payments to his first family. The law effectively told Henry that he had to provide for his first children at a suburban middle-class level, even if it meant his new child was living in relative poverty. Step by step, the pressure on the remarried man became an endurance test. The first step was the household budget war. Because the first wife often had the right to audit the husband's earnings through the court, any increase in Henry's prosperity was immediately met with a legal filing for more money. If Henry got a promotion, Beatrice's lawyer would argue that the first children deserved a share of that new success. Sarah, the second wife, would watch as the extra income that could have gone toward her child's education or a better apartment was siphoned off to a woman she had never met. Historical trends show that this created a massive amount of friction between second wives and the legal system, often leading to second marriages failing under the weight of the first marriage's debt. The potential outcomes for a man in Henry's position were often grim. If he couldn't make the math work, he would frequently fall into arrears. In 1960, the collection of child support across state lines was difficult, but within the same state, it was ruthless. A man who was remarried was often seen by judges as someone who had abandoned his original responsibilities. Judges would lecture men like Henry from the bench, telling them they had no right to start a second family if they couldn't perfectly maintain the first. This moralistic approach ignored the reality of human emotion and the economic boom of the era that encouraged expansion and new beginnings. Consider the case study of a man named James in Ohio. James was a veteran who remarried in 1959. His second wife, Carol, worked as a secretary to help make ends meet. However, the first wife's attorney discovered that Carol was working and argued in court that since James's total household income had increased, his alimony payments should also increase. Effectively, the court was trying to tax the income of the second wife to benefit the first. This was a common tactic in the late 50s. The second wife was working not for her own future, but to pay for her husband's past. This led to a generation of second wives who became the fiercest advocates for divorce reform, realizing that the fault-based system was a parasite on their own domestic stability. This brings us to the alimony trap for women, which conversely trapped the men. In the 1950s, alimony almost always ended if the woman remarried. This created a perverse incentive. A first wife might live with a new partner without marrying him specifically to keep the alimony checks coming from the first husband. The man, meanwhile, was legally prohibited from stopping the payments unless he could prove she was cohabiting, which in the 1950s required a level of surveillance that was both expensive and often considered tawdry by the courts. A man could be paying for his ex-wife's lifestyle while she was effectively in a new, stable relationship, while he and his new wife struggled to buy groceries. The data from the period indicates that this financial strain was the leading cause of the heart attack decade for American males. The physical toll of working multiple jobs to support 2 households, while navigating the constant threat of contempt of court charges, was immense. Men like James and Henry were the faces of the silent generation, men who didn't talk about their feelings, but whose blood pressure readings told the true story. They were the engines of the post-war economy, but they were being redlined by a legal system that refused to acknowledge that people change and marriages end. Imagine if you were in James's shoes in 1960. You are 42 years old. You spent your 20s fighting in the Pacific or Europe. You spent your 30s building a career and a family. Now in your 40s you are working 60 hours a week and you have less disposable income than you did when you were 21. You see your first family only 4 days a month, and when you do, you are treated as a source of funds rather than a father. Your second wife is resentful of the money leaving the house. Your children from both marriages are sensing the tension. The state, rather than helping you navigate this, is acting as a collection agency for your past. This era also saw the rise of the private investigators for the defense. Men began to hire PIs not to catch their wives in adultery to get a divorce, but to catch their ex-wives in cohabitation to stop the alimony. This was a dark mirror image of the pre-divorce surveillance. Men would spend their meager savings hoping to get a photograph of a new man's car parked overnight at their ex-wife's house. It was a race to the bottom, a system that turned former partners into lifelong spies. Step by step, the 1950s man was being radicalized by his own checkbook. He began to see that the family values touted on television were a one-way street. He was expected to provide the value, but he was given no protection when the family unit dissolved. This feeling of being an outlaw provider is what started to shift the political landscape. By 1961, the first organized efforts to change the tax code regarding alimony began to take shape. Men were demanding that if they were forced to pay, they should at least be able to deduct those payments from their taxable income to avoid being taxed on money they never touched. But the biggest shift was yet to come. As the 1960s began, a new generation of lawyers, men who had seen their own fathers destroyed by these laws, started entering the bar. They weren't interested in the moral theatrics of the fault-based system. They were interested in contract law and civil rights. We are about to look at the first cracks in the tender years doctrine, and the radical lawyers who started arguing that a father's love was just as valuable as his paycheck. We are going to explore the landmark cases where a man finally won custody, a move so shocking it made national headlines and sent tremors through the American household. What happens when the visitor demands to be a parent? The answer lies in the legal revolution that was about to turn the 1950s world upside down. The next part of our masterclass reveals the beginning of the end for the Sunday dad and the rise of the modern custody battle. The transition from the late 1950s into the early 1960s was marked by the first serious legal tremors underneath the tender years doctrine. To understand how radical this shift was, we have to look at the historical trends of judicial thinking. For decades, the American courtroom operated on a biological assumption that was almost religious in its intensity. The idea that a mother's bond was mystical and absolute, while a father's role was purely economic and secondary. But as the 1960s approached, a small group of pioneering lawyers began to use the emerging science of psychology to challenge this. They began to argue that a child's developmental needs were not sex-segregated. They argued that maternal preference was not a law of nature, but a rebuttable presumption of the court. Imagine a man named William in 1961. William is a high school teacher in Virginia. His wife has left the home to pursue a life that clearly does not involve their 3-year-old daughter. In 1955, the court would have likely awarded custody to the mother regardless of her lack of interest, perhaps placing the child with a maternal grandmother before ever considering the father as a primary caregiver. But William's lawyer decides to do something unheard of. He brings a child psychologist into the courtroom. This was the first step in the dismantling of the old guard. The psychologist testifies that the daughter has a primary emotional bond with William, and that removing her from his care would cause permanent psychological trauma. This was a high-stakes gamble. In 1961, judges were often older men who viewed psychology with deep suspicion. However, the data from these early case studies shows that the introduction of expert testimony began to create the first cracks in the wall. William wasn't just asking for visitation, he was asking for the right to raise his child. He was challenging the very definition of 1950s masculinity. For the first time, a man was standing in a U.S. court and saying that his value was found in the nursery, not just the office. The potential outcomes of this case were massive. If William won, it would signal that the state no longer viewed fathers as mere visiting bank accounts. The legal strategy involved a step-by-step deconstruction of the mother's fitness. Because the fault-based system was still in play, William had to prove that the mother had abandoned her sacred duty. This was a brutal process. It forced fathers to become investigators of their own wives' failures. To win custody, a man in 1961 couldn't just be a good father. He had to prove the mother was an exceptionally unfit person. This often involved proving alcoholism, neglect, or moral turpitude. It was a scorched earth policy. If the father failed to prove the mother's unfitness, the court would revert to the tender years doctrine and he would lose everything: his child, his home, and a massive portion of his income. Despite the risks, these cases began to appear in law journals across the country. They were the black swan events of the legal world. When a father won custody in 1962, it was such a shock to the social system that it often led to front-page news in local papers. It challenged the neighbors' perceptions. A man raising a child alone was seen as a tragic figure, or worse, a suspicious one. Society didn't have a category for the single dad. There were no playgroups for him, no support networks, and his boss at work likely viewed his domestic responsibilities as a distraction from his professional productivity. Step by step, the 1960s man began to demand a best interests of the child standard that was gender-neutral. This was the birth of the modern custody battle. It shifted the focus from who is at fault for the marriage ending to who is the better parent for the child's future. For the first time, men began to document their parenting. They kept logs of every meal they cooked, every diaper they changed, and every doctor's appointment they attended. They were building a parenting portfolio to present to a judge. This was the beginning of the end for the Sunday dad, because it forced the legal system to acknowledge that fatherhood was a verb, not just a title on a birth certificate. But as men gained ground in custody, the financial retaliation from the old system intensified. Since the man was now taking on the primary care of the children, argued that he shouldn't have to pay alimony to a woman who was no longer raising them. The courts, however, were slow to catch up. There are case studies from 1962 where men were granted custody of the children, but were still ordered to pay spousal support to their ex-wives. The reasoning was that the wife had sacrificed her career potential during the marriage and was entitled to be maintained by the husband regardless of whether she was parenting or not. This led to the double burden era, where a man was both the primary breadwinner and the primary caregiver, while still funding the lifestyle of an ex-spouse who had no domestic responsibilities. This economic friction is what eventually led to the 1960s push for equal rights to be applied to men in domestic relations. It was a radical idea. If women were to enter the workforce and seek equality, then men should be entitled to equality in the home and in the divorce court. The men of the early 60s were the silent architects of this domestic revolution. They were the ones who sat in their lawyers' offices and refused to accept the standard visitation schedule. They were the ones who pushed for joint custody, a term that was virtually non-existent in the 1950s. Imagine the conversation in a corporate boardroom in 1963. An executive tells his manager he can't stay late for a meeting because it's his night to pick up his children. In 1953, that man would have been laughed out of the building or fired. In 1963, he was the vanguard of a new type of American male. He was a man who had been through the fire of a fault-based divorce and had come out determined to be more than a paycheck. He was willing to risk his career and his reputation to maintain a real relationship with his children. The data suggests that this shift in the early 60s was primarily driven by the World War II generation, reaching their late 30s and 40s. These were men who had seen the world, who had seen death and destruction, and who were no longer willing to be bullied by a provincial legal system that treated them like children. They wanted a new deal for the American family. They began to fund legal defense funds for fathers and started the first divorce newsletters that shared tactical advice on how to survive a contested custody hearing. However, the Sunday Dad model didn't go down without a fight. The legal establishment fought back by increasing the standards of proof for fathers. A father didn't just have to be as good as a mother. He had to be superhuman. He had to have a perfect house, a perfect job, a perfect moral record, and a plan for 24-hour childcare. The mother, by contrast, was still given the benefit of the doubt. This superdad requirement was a form of institutionalized discouragement. Most men looked at the requirements and realized they simply couldn't meet them, while also working the hours required to pay for the legal battle. This brings us to the most pivotal moment in the history of U.S. divorce: the rise of the pro se litigant. Men who were financially drained by years of alimony and legal fees began to represent themselves in court. They walked into the hallowed halls of justice with no law degree, but with a mountain of evidence and a burning sense of injustice. They were the guerrilla lawyers of the 1960s. We are about to dive into the story of the men who took their cases all the way to the state Supreme Courts, challenging the very constitutionality of the fault-based system. We are going to look at the landmark 1960s rulings that paved the way for the no-fault revolution. What happens when a man decides that the law itself is the enemy? The answer is a legal explosion that would redefine the American family forever. We are entering the era of the Great Reform, and the stakes have never been higher. The year 1964 represented the absolute breaking point for the traditional American divorce framework. For over a decade, the 1950s man had been squeezed by a system that demanded he be a stoic provider, while treating him as a legal outsider in his own home. But as the mid-60s arrived, the frustration that had been simmering in the basement apartments and boarding houses across the United States began to manifest as a direct legal assault on the status quo. This was the era of the guerrilla litigant. Imagine a man named Leonard, Leonard is a 45-year-old aerospace engineer in California. He has been through 3 years of litigation, has exhausted his savings on 3 different attorneys, and has seen no progress in his quest to simply have his children stay at his home on weekends. Leonard makes a radical decision. He fires his lawyer and decides to walk into the courtroom with nothing but a stack of law books and his own voice. In 1964, a man representing himself in a domestic relations court was seen as an act of madness. Judges viewed pro se litigants as nuisances who didn't understand the complex rules of evidence or the traditional decorum of the bench. However, Leonard and men like him began to realize that the professional legal community had a vested interest in the status quo. Every motion, every delay, and every contested hearing generated fees. By representing himself, Leonard was no longer playing by the rules of the guild. He began to challenge the very core of the fault-based system. He argued that the requirement to prove a crime to exit a marriage was a violation of his constitutional right to liberty. This was the first step in a strategy that would eventually reach the highest levels of the American judiciary. Leonard's approach was a step-by-step deconstruction of the 1950s moral code. He didn't argue that he was a victim. He argued that the law was obsolete. He pointed out that historical trends were shifting toward a society where individuals had the right to self-determination. If the state couldn't force a man to stay in a specific job, how could it force him to stay in a specific contract of the heart? This intellectual shift was terrifying to the conservative establishment. They realized that if Leonard won, the entire industry of private investigators, professional correspondents, and fault-based attorneys would vanish overnight. The potential outcomes for these early reformers were often characterized by intense retaliation. Judges would hold these men in contempt for the slightest procedural error. They would intentionally schedule hearings at times that would force the man to miss work, further jeopardizing his employment. But the data shows that the volume of these filings began to clog the court systems of major states like New York and California. The backlog became so severe that the state governments were forced to acknowledge that the current system was no longer functional. It was a war of attrition. Men were flooding the courts with motions for special circumstances, demanding that the court recognize their right to be parents and their right to financial survival. Consider the case study of a man named Harold in New Jersey in 1965. Harold was a veteran of the Korean War and a meticulous record keeper. When he was sued for divorce on the grounds of extreme cruelty, a total fabrication by his spouse to secure the house, Harold didn't just deny the charges. He countersued, alleging that the very statute of extreme cruelty was unconstitutionally vague. He argued that because the law didn't define what cruelty was, it gave judges the power of a dictator. Harold's case became a rallying cry for local Fathers groups. They realized that they didn't have to win every case. They just had to make the old system too expensive and too complicated to maintain. This period saw the emergence of the Divorce Reform Association, which began to coordinate these legal attacks. They weren't just sharing survival tips anymore. They were drafting model legislation. Step by step, they were preparing for the day the fault-based wall would fall. They focused on 3 specific goals: the abolition of the tender years doctrine, the implementation of no-fault divorce, and the creation of alimony guidelines that were based on math, rather than a judge's moral whim. They were trying to turn divorce from a moral theater into a business liquidation. The pushback was massive. Religious organizations argued that removing fault would destroy the incentive for women to be virtuous and for men to be responsible. They claimed it would lead to a divorce-on-demand culture that would ruin the American child. But the men of the mid-60s had an answer. They argued that the current system actually encouraged lying, perjury, and social decay. They pointed to the Reno Cure and the professional correspondent as proof that the law was making criminals out of ordinary citizens. They were winning the intellectual argument because they were the ones living with the consequences of the failure. Imagine the atmosphere in a 1965 legislative hearing. On one side, you have the traditionalists in their robes and clerical collars. On the other, you have a line of men in gray flannel suits, engineers, teachers, and mechanics, who are presenting data on how the current laws are driving fathers into bankruptcy and children into fatherless homes. This was the moment the organization man turned into the rebel with a cause. They were using the very skills they had learned in the corporate world, data analysis, strategic planning, and public relations, to dismantle the laws that had trapped their fathers. We must also look at the role of the new professional woman in this reform. By 1965, more women were entering the workforce and realizing that they, too, were trapped by these archaic laws. If a woman was the primary earner and wanted a divorce, She could be forced to pay alimony to a guilty husband. The realization that the law could cut both ways led to a brief, unusual alliance between the early men's rights reformers and the burgeoning feminist movement. Both groups wanted the same thing: a legal system that treated adults as equals who could make their own decisions about their lives. Step by step, this alliance began to influence the American Bar Association. In 1966, a commission was formed to study the possibility of a Uniform Marriage and Divorce Act. This was the first official acknowledgement that the 1950s system was dead. The data they collected was staggering. It showed that the fault-based system was the single largest source of perjury in the American legal system. It showed that the tender years doctrine was based on 19th century theories that had no basis in modern behavioral science. The momentum was shifting, and the man of 1966 could finally see a light at the end of a very long, very expensive tunnel. But as the old laws began to crumble, a new and unexpected danger emerged. As the legal system prepared to transition to a no-fault model, the settlement industry went into a frenzy. Realizing their lucrative business was about to be regulated out of existence, attorneys and private investigators began to push for grandfathered settlements. They tried to lock men into permanent, unchangeable decrees before the new laws took effect. This led to a final brutal wave of midnight settlements, where men were pressured into signing away their futures one last time. We are about to reach the climax of this masterclass. We are moving into the final part where we look at the actual birth of no-fault divorce and the aftermath of the 1950s era. We will explore the long-term psychological legacy on the men who survived this system and the children who grew up in its shadow. We are going to look at the 1969 California law signed by Ronald Reagan, the first no-fault law in the nation, and how it changed the American male experience forever. Was it the liberation men had fought for, or did it simply trade one set of chains for another? The final chapter of this deep dive reveals the ultimate cost of the 1950s divorce and the lessons that the man of 2026 must never forget. The conclusion of the masterclass starts now. The climax of this legal saga occurred on September 4, 1969, when Governor Ronald Reagan signed the Family Law Act in California. This was the first no-fault divorce law in the United States, and its arrival signaled the formal end of the 1950s era. For the mid-century man, this was the moment the cage door finally swung open. But as we look back from the year 2026, we can see that the transition was far from a clean break. The 1950s system didn't just disappear. It left a deep structural scar on the American male psyche and the way family law would be practiced for the next 60 years. To understand the impact of the no-fault revolution, imagine a man named Kenneth. Kenneth is 55 years old in 1970. He has been trapped in a dead marriage for 15 years because he couldn't afford the fault-based ransom of the 1950s. Under the new California law, Kenneth can finally file for divorce without proving his wife is a criminal. He doesn't need staged photos. He doesn't need to hire a professional correspondent. He simply states that the marriage has suffered an irremediable breakdown. For Kenneth, the potential outcomes included a profound sense of relief, but also a staggering realization of the time he had lost. He had spent his entire prime working years as a captive of an archaic moral code. However, the 1950s era left behind a financial legacy that would plague men for decades. Even as no-fault laws spread across the country throughout the 1970s, many of the old permanent alimony orders from the 1950s remained in place. These were known as zombie decrees. Historical trends show that men were still paying for divorces granted in 1955 well into the 1980s and 1990s. Because these orders were often permanent and lacked cost of living adjustments or termination clauses, men were legally bound to their 1950s pasts even as the world around them became unrecognizable. Step by step, we have to examine the long-term psychological fallout for the children of these 1950s divorces. These children, many of whom are now the elders of 2026, grew up in the shadow of the tender years doctrine. They were the first generation to experience the mass erasure of the father figure. The data from longitudinal studies suggests that the forced distance between 1950s fathers and their children created a specific type of emotional vacuum. The men who were relegated to Sunday dad status often struggled to form deep, authentic bonds with their adult children later in life. The legal system hadn't just separated households, it had broken the chain of paternal transmission. The lessons of resilience, craftsmanship, and stoicism that these fathers might have passed down were lost in the transactional nature of 5-hour visitation windows. Consider the case study of a man named Gary. Gary's father was a 1950s divorce victim who lost everything in a 1958 settlement. Gary only saw his father twice a month. By the time Gary was an adult in the late 1970s, his father was a broken man, still working a manual labor job at age 65 just to cover the remaining alimony debt from a marriage that had ended 20 years prior. Gary's view of marriage was fundamentally altered by watching his father's slow-motion financial and emotional liquidation. This is the hidden cost of the 1950s system. It turned marriage into a high-risk liability in the minds of the subsequent generation, contributing to the declining marriage rates we see in the late 20th and early 21st centuries. The 1950s man was the sacrificial lamb of the modern domestic era. He was the one who proved that a system based on shame, lies, and financial ruin was unsustainable in a modern economy. The shift toward equitable distribution and joint custody that we enjoy in 2026 was paid for by the misery of the men in gray flannel suits, who were treated as disposable bank accounts. They were the ones who sat in the back of courtrooms and realized that the law didn't care about their hearts, only their ledger. But what is the ultimate lesson for the man of today? The historical trends show that whenever the state involves itself in the intimate contract of marriage, it does so with a heavy hand that often lags 30 years behind social reality. The 1950s man was punished for living in 1955, according to the rules of 1895. We must understand that the legal protections we have now, mediation, shared parenting, and limited-term alimony, were not granted out of benevolence. They were won through the stubborn resistance of the men who refused to vanish, the men who represented themselves, and the men who dared to love a second time despite the crushing math of the first. Imagine if the men of the 1950s could see the world of 2026. They would see a world where a father has a legal right to be a primary caregiver from day one. They would see a world where alimony is a bridge, not a life sentence. But they would also warn us. They would warn us that the legal system still thrives on conflict. They would tell us that the moment you enter a courtroom, you are no longer a person. You are a case file. Their story is a reminder that the most important legal protection a man has is his own awareness of the system's history. The 1950s divorce wasn't just a domestic event. It was a cultural trauma that redefined American masculinity. It forced men to find value outside of being the head of the household. It gave birth to the modern independent male who understands that his identity is not tied to a property deed or a marriage certificate. As we close this masterclass, we have to look at the final haunting statistic from that era. In 1959, at the height of the fault-based system, the suicide rate for divorced men was significantly higher than for any other demographic. They felt they had no way out, no way forward, and no way to be heard. We tell their story now so that their silence wasn't in vain. The deep dive into the 1950s male experience reveals a truth that is still relevant today. The law is a reflection of society's fears, not its fairness. The fear in the 1950s was the collapse of the nuclear family, and men were the ones forced to pay the price for that fear. Today, the landscape has changed, but the underlying mechanics of power and finance remain. By understanding the blueprint of the mid-century divorce, the man of 2026 can navigate his own life with a level of clarity that his grandfather never had. But our journey through the history of the American male experience is only beginning. We have mastered the dark history of the 1950s divorce. There is a whole other side to this story. What happened to the men who stayed? What happened to the secret lives of the suburban breadwinners who were too afraid to leave? And more importantly, how did the rise of the 1960s counterculture specifically target the 1950s father as the ultimate villain of the American story? We are about to pivot from the legal battlefield to the cultural one. In our next deep dive series, we are going to explore the great betrayal of the 1960s and the rise of the anti-father sentiment that changed Hollywood, politics, and the American school system forever. If you think the courtroom was brutal, wait until you see what happened in the classroom and on the silver screen. The 1950s man survived the law, but could he survive the revolution? The next masterclass starts with the collapse of the 1950s icon and the birth of the modern identity crisis.